Bob Iger is going to be salty today as Disney has lost in court. And this loss, while it's in the state court case, will impact both trials and can absolutely destroy Disney's chances at victory and really destroy the Disney narrative. This is massive and huge. And what's even bigger is the judge adopted my reasoning. That's right. What we've been talking about on this channel for the past, I don't know, year has been confirmed by the Florida judge. It feels so good to be right. So on this channel today, we are going to go through this motion. I am the only Florida lawyer covering this thing who knows what they're talking about, was experienced in special districts and Florida real property law. So we're going to get right into this today and exactly what we're talking about when we're talking about this case. Of course, this is The Legal Mindset. We teach you to be your own judge. And I'm Andrew Esquire, a Florida attorney currently living over here in Asia. But happy to talk about all things Florida, as I spent almost a decade in special district law, dealing with districts like the former Reedy Creek, the new Central Florida Tourism Oversight District, which is indeed part of this case. In fact, this case, for those who need a little bit of a refresher here, there's two cases. There's a state case and a federal case. But in this particular case, we're dealing with the Central Florida Tourism Oversight District versus Walt Disney Parks and Resorts Incorporated. This is the state case. It is 2023 CA 0118. 18-0. You can look this up for yourselves online. And we're going to go into the order denying the motion to dismiss. So Disney was trying to dismiss the Central Florida Tourism Oversight District's case. Now, this case is all about whether those last-minute dirty deal contracts were valid. Why is that important? Well, it's important because most, but not all, of the claims in Disney's federal case were based on these dirty dealing contracts and amendments. These developer agreements and restrictive covenants they tried to put in at the last second. So this last second deal, it's all about whether that's valid. Now, Florida, both in the state legislature and the district itself, have found that these agreements were void ab initio. And no, it's not Harry Potter. That means they're as if they never happened, right? However, I said all along that yes, it's very important that those bodies also void them, but you need to, under the statute, really have a court of competent jurisdiction rule on this. In order to make it final, in order to confirm it, the role of the court is to confirm that yes, they are indeed void ab initio, because Disney holds out that no, in fact, they're still valid. And in fact, that they would be valid but for some state laws. So Disney has a different view on these contracts and their potential validity. They say, no, it's not because they're void ab initio, i.e. void from the start. It's because they were voided by subsequent law passed by the state of Florida, which interfered with them. There's a big difference in that. And what this order says is it pretty much says, hey, Disney, I know you wanted to get rid of the state case and you wanted to take this to federal court because you feel that's more favorable to you and you have that First Amendment argument, which everybody in the mainstream media thinks is sexy. But in fact, now they are not going to get to do this. So we're going to skim this, but I am going to go into legal analysis because, as always, I am the only person who's ever really gone at this in depth. Everybody else has either just read it without any analysis or, well, doesn't know what they're talking about. So when we jump right into this, we see this is obviously on the case. This hearing was held on July 14th in the case between Central Florida Tourism Oversight District and Walt Disney Parks. These are both Florida parties, so of course, Florida venue, Florida jurisdiction is appropriate. Now there's background here on the district and when it was established. Obviously, it was established as Reedy Creek initially, but it was renamed to the Central Florida Tourism Oversight District under Governor DeSantis. So initially, it was known as RCID until February 27th, where it now still exists as the Central Florida Tourism Oversight District. So the contracts, which you often hear them talking about, or agreements more properly, were the developer agreement, which is a type of statutory agreement. You can see right here, they mention it as a Chapter 163. That is a Florida statute. So there are specific requirements of that contract. It's something that has very specific parameters under the law. And by the way, the only way to invalidate one of these is really by going to court. So that's one thing that I said from the beginning, hey, they're going to have to go to court because it's something that requires a court process to break up. Second, they have restrictive covenants, which are recorded subject to that developer agreement. So they were kind of within that developer agreement was a requirement to record restrictive covenants. So this kind of things go hand in hand. We're just going to say the agreements because that's what they call them here. And I believe that's accurate to talking about them. Now, what they wanted to do here is to control Disney's future land use and development within the district, including the district's own land. So it didn't want to just control Disneyland. It wanted to control what the district, what the government did on its own land and make sure that what the government does is consistent with Disney's private plans. This is the exact bleeding over of public and private that was impermissible in the first place. But Disney was trying to do it. It's like an HOA taking over your city and telling the city how to run. That's not how it's supposed to work. It's not how it's supposed to work. So the appropriate way to fight a restrictive covenant is to go to court, which they're in. They're in circuit court for Orange County, Florida. So that's within the restrictive covenants themselves, and that's the appropriate place to take them. That's why this thing came to court. Of course, there is a federal lawsuit, which is currently in the North District of Florida. It's against not just the members of the district individually, in their official capacity, but individually, but also against Ron DeSantis. It's the sexier case. It's the case that everyone wants you to know about. But yet today, because of this case, because of this motion to dismiss and Disney losing this federal lawsuit is at risk. In fact, I can say today on this channel, and I'll make myself big for this, this is the day that Disney really loses their federal case, because their federal case is going to be thrown out because of this. It's going to either stayed or dismissed because the state case is going to proceed. And these two cases can't really go on at the same time. So they're going to need to pause that federal case. So it's really the day that federal case dies. So let's go to the background of the federal case. And we're not covering the federal case today, but just so you know, they alleged various constitutional allegations. However, the important thing is in that federal case, they do not allege any state law claims. This is very important because they wanted to try to stay in federal court. They did not want to go to state court in Florida. However, all of this was fundamentally based on state law. It was based on these laws that you see here that are fundamental to the state of Florida, that are Florida-based, that are not based on federal law or constitutional law. The fundamental elements are within the state of Florida. So always this thing was something that needed to be handled in state court. That being said, the state lawsuit wanted to find these agreements void ab initio. So they want a ruling on the validity of the agreements, regardless of the ability of Disney to enforce the agreements. See, Disney in its state case is talking about the enforceability, but underlying this is if their agreements aren't valid, it doesn't matter whether they're enforceable. So you can see that as a precedent, something needs to be valid, number one, before you can enforce it, number two. If you have a contract that's bunk, you can't go and try to collect on that contract. And that's what we have here. We have a contract that is bunk. No proper notice, no consideration, illegal terms, all sorts of problems in that original contract and those agreements. And because of that, they're invalid. There's no question of whether or not to enforce them, so you don't even get to the federal lawsuit. That's the real problem here. But let's get down to the court analysis. So number one, the first way in which they agree with me is they say the issue, and this is the judge saying the issue of whether the agreements are void ab initio will not be resolved until a court of competent jurisdiction decides the issue in favor of one party or another. The issue is still alive and still has real world consequences for both parties. The district is still a government facing uncertainty regarding the extent of its power to govern and the risk of litigation until a court of competent jurisdiction finally decides the status of the agreements. These are held like a sword of Damocles over the district's head. They can't have this. It needs to rule on this immediately. And because of that, Disney's argument, oh, well, this is moot because, the legislature asked it on it and we have a federal lawsuit. Totally oblivious to the way that these things are dealt with in state court and under state law. And that's because they got a bunch of lawyers from out of state, from California, from New York, a bunch of liberals from DC, all these people who don't know Florida law. And their one lawyer in Florida who, pro hoc vitae'd their, let in these out-of-state lawyers, let them into Florida. But really, they're the ones running the show. We all know that the out-of-state libtards are the ones that are running this case because only someone who is demented would think that they could win under Florida law. That being said, when you go through this, they kind of confirm here that the statutes, right, that the statutes need to be voided. The statutes require that they void disagreements, right, that they void the agreements. So they need to go through and actually rule them void. So they're not moot at all. They need a declaratory judgment to remove any doubt as to the practical need for declaration was assuaged. Let me go right back up. They need a declaratory judgment to have finality, right? To finish this off. So second of all, a declaratory judgment will have great and actual effects and collateral legal consequences over a question of great public importance, which is capable of repetition. This is what I've been saying. This will happen in every single HOA if you allow it to happen. If you allow one single public entity to lose its power to a private corporation, this will happen everywhere in the state of Florida. This is a huge precedential effect because it fundamentally changes questions of great importance. Right here is the admission by the judge. They contradict the legislature's policies towards the district and would permit Disney all development rights and land use regulations in one of the most heavily visited areas in Central Florida. These issues implicate matters of the state's sovereignty, their delegation of sovereign power. That's why it's huge. This is massive. Cities, counties, special districts, those are pieces of the state. Those are pieces of the state's sovereignty. So to mess with that is to mess with the entire state. And that's, of course, of great interest to the economy and citizenry. When a private corporation is allowed to usurp the state's sovereignty, yeah, that's an issue. It's a big issue. And so these things could be likely to recur. And I say they would recur because there's no way that somebody else wouldn't try a similar thing. Next, they talk about the entitlement to a stay. Obviously, Disney is not entitled to a stay. In this case, in fact, they write here, the federal court should bend the knee to the state court. In this case, the state court, Disney's claims arise under Florida law. And Disney and the district are both citizens of Florida. All of this has really been a Florida law issue to begin with. Disney has wanted to dodge this, but in this, the judge is agreeing here that what we have is entirely a Florida issue. This has always been a Florida issue. It's never been a constitutional issue or anything else. It is a Florida law issue. Second of all, the kind of sub-argument here is Disney had argued that there was a race to the courtroom and whoever files first gets in first. That's irrelevant. That doesn't apply here, so they don't need to look at that analysis. I said this before. The court is agreeing with me. That whole race to the courthouse argument, that's very outdated. It's very childish. It's kind of an element of procedural fuckery that Disney was trying to win on. And of course, there's no other considerations in Disney's favor. In fact, all of the considerations, they actually warrant denying Disney and keeping this case going because it's so important, because this is so fundamental to the exercise of state law. So this is ordered by the judge, Margaret Schreiber, as of the 20th day of July. So this is fresh off the press. This is fresh out there, and this is a fresh loss for Disney. Let me know what you guys think of this. Do you like me covering these and again giving you the legal analysis? It has been amazing to see people fight back against this, rage and flip out and go crazy. So make sure you're spreading this out. Spread that out there on Twitter or everywhere else you can. And I wish you all the best, and we'll talk to you guys later. Take care. Peace.